Hi there, I'm Ron Wright and I teach here at the law school at Wake Forest University. We're going to be talking today about searches of cars. There are a lot of different legal theories under the Fourth Amendment, the part of the Constitution that prohibits unreasonable searches and seizures. So there are a lot of different theories that police and prosecutors and defense attorneys talk about as they're asking, can the police search for evidence of a crime in a car? So let's go talk about car searches. Okay folks, let's get started. We're going to be talking about searches of cars. There are some special Fourth Amendment search and seizure rules when it comes to cars. We're focusing on the search rules, not the seizure rules. So there are separate rules for when can you stop a car. You need some kind of reasonable suspicion to believe that the driver has violated some criminal law or traffic law. But we're not talking about the stops. We're talking about the searches. Once the car is stopped, can an officer look inside the car to try to find evidence of some kind of crime happening? In this setting, there are lots of different theories that the government can use. We're going to talk briefly about four of them, just a quick overview of four theories. But the big idea here, your rule of thumb is government's probably going to win because they've got a lot of different ways of explaining, ways of justifying the police officer searching inside the car. Lots of different theories, therefore lots of different ways to win. Government's probably going to win. We'll walk through the four different theories. First of all, here's theory number one. This is called the Carroll theory, or the automobile exception to the warrant requirement. So this was established in a case called Carroll versus United States in 1925. Like a lot of 1920s cases, this dealt with prohibition of alcohol, and the federal agents and state agents were out looking for illegal transportation and sale of alcohol. And so they stopped a car and were looking inside the car for alcohol, but they had no warrant. And at that point, it was not clear whether you needed not only probable cause to believe that alcohol was in the car. This is not just a fishing expedition, but you have some reason to think this car will have alcohol in it. But not only, in some settings, the question is, do you not only need probable cause, but you need to go to a judge ahead of time and convince the judge and get the judge to give you a warrant, and then you can search. And the court's answer in Carroll versus United States was, no, if it's a car, we're just going to give up on the whole warrant thing. We're not going to make you go get a judicial pre-approval of your probable cause. And the court had a few reasons for that, but one of them was, cars are just easy to move. And so, if you were going to a house and you thought there was evidence in the house isn't going anywhere. So you have time to go to the judge and get the warrant and then come back to the house and get your evidence. But for the car, cars can move. It's easy, maybe you see it there now, but you turn around 3 minutes later, it's gone, or maybe even 30 seconds later, it's gone. So the idea of cars being movable influenced the court here. And also the court had some passages indicating that cars are sort of in a more public place than being in your home. That is, we think of ourselves as being out in public when we're in our cars on the roads. And so you give up more of your privacy if you've chosen to go out in that part of the world. So at any rate, the court says no warrants required in a car. They've reaffirmed that idea several times over the years, including Chambers versus Maroney in 1970. But that's the basic idea. There is one little side area here on this warrant idea. If you have a container within a car, it was not clear all along the way whether you needed a warrant to get inside the container. So for instance, if I have a briefcase and it's latched shut and I carry the briefcase and put it in the car, now that it's in a car, do you need to can you look inside the briefcase without a warrant, or do you treat the briefcase as something that requires a warrant, as if it were sitting in a house or an office or something? And the basic answer the court has given after some back and forth over the years is that no, you don't need a warrant just because there's a closed container in the car. So no warrant for the car and no warrant for the containers within a car. There are a few limits on this. So for instance, if I have probable cause that is limited to a container, I think somebody's carrying, illegal paper, illegal bonds, counterfeit bonds in a briefcase, and I watch them walk to their car, get in, and then I immediately, approach the person and want to search. Well, there hasn't been any opportunity to move the counterfeit bonds somewhere else in the car, so I can't at that point say, aha, warrant exception, Carroll, I get to search the whole car because I know that you put something illegal in the car. No, if I know that my probable cause is limited to a particular place in the car, like in the briefcase, or I see somebody put the thing I'm suspicious about in the glove compartment, I can't then go and search the trunk. So the probable cause only extends to the areas where, I saw it go in. Probable cause might be limited to a sub area of the car. On the other hand, if somebody goes to the car, goes around a corner, I can't see them, they're in their car for a minute or something before I arrive and ask to search, maybe in that amount of time they could have moved the counterfeit bonds or some of them somewhere else in the car. And so at that point I do have probable cause that extends to the whole car. So that's theory number one, the warrant exception, the automobile exception to the warrant requirement under Carroll. Theory number two, a Terry frisk of a car. So remember, with a Terry frisk, if I approach a pedestrian, I'm an officer and I approach somebody and I have reasonable suspicion to stop them, and I have reasonable suspicion to believe that they're armed and dangerous, if I have both of those two types of reasonable suspicion, then I can do a quick pat down of their outer clothing. I can't do a full search, empty your pockets and everything, but I can do a quick pat down frisk search. The same is true for a car. There's a sort of analogous version where we think of this as a frisk of the car. So if I appropriately stop a car, I had reasonable suspicion to stop the car, and I have reasonable suspicion to believe that a person in the car, the driver or a passenger, is armed and dangerous. They might threaten me after we finish the car stop, and as I'm driving away, they may get out their gun and fire at me, or they may get out a knife and try to cut me while I'm talking through the window. If I have some kind of articulable, reasonable suspicion to believe that this person is armed, then I can say, please get out of the car, and I can search the reachable area basically within the passenger compartment of the car, looking in places where a weapon might be hidden. I can't go back in the trunk because that's not accessible to a person who might threaten me. But I can look in a fairly generously defined reachable area within the passenger compartment to look in places where a weapon might be stored. Now, if I'm looking for, if the weapon I think might be present would be a rifle, well, that obviously limits the kinds of places that I can look. But if I'm looking for a small knife, lots more places in the car are now fair game for me to look. But that's the second theory, searching for a weapon, or a sort of a frisk of the car under the theory of Terry. Third theory, you can have a search incident to arrest if you're in a car. So remember, if I am arresting a person, in a public place, it's just a person sitting in a chair or walking across the street or whatever, I can arrest them based on probable cause, and then I can automatically search them, and maybe the handbag that they're carrying or the briefcase or whatever, I can just search that automatically as part of the arrest, even though I don't have any particular probable cause to believe that there's a weapon or evidence of a crime on the person at that time. This is just an automatic extension of the arrest power. Well, the same thing happens in the setting of an occupant of a car. If I have probable cause to arrest somebody and they're in a car, then part of my power to search incident to arrest includes searching the immediate area within the car, again, the reachable area as with the Terry frisk. Where it becomes interesting is what happens if I have probable cause to arrest somebody, they pull over, get out of their car, and by the time I get to them, they're 10, 12 feet away. Now what do? We've got a case specifically on this, Arizona versus Gant, that tells us now that the police have more limited power to search incident to arrest if it's a recent occupant of a car, somebody who stepped away from the car even though they were there just moments earlier. So in this setting, the court has said you can search a recent occupant or the car of a recent occupant after that person's arrest, but only if the car is within reaching distance, if the person's close enough to the car that you could imagine them jumping back to the car and grabbing that gun and threatening the officers. Or another possibility is if it's reasonable to believe that the vehicle contains some kind of evidence of the offense that I arrested them for. So if it's reasonable to believe that, I'm arresting them for drugs and evidence of that drug offense are in the car, then I can search in the car for that evidence. This gets back to the original reason for the search incident to arrest. The original idea was, first of all, to protect the safety of the officer. Don't want to be arresting someone and they've got a gun or a knife or whatever on them and the officer doesn't know about that. So the same rationale applies if the person's in the car. It becomes a weaker justification if the person's away from the car and can no longer reach the car. So that officer safety idea has its limits, and the Gantt case explores those limits. The search incident to arrest doctrine also is there to help with the preservation of evidence, so that you don't want somebody, if they've been arrested, then while they're, let's say, being transported to the station or being put in the car, they kind of drop something, pull it out of their pocket and throw it away. You want to be able to figure out exactly what's on the person and preserve all the evidence once you have probable cause to arrest. Again, that's less likely to be a worry if you arrest somebody who's a recent occupant of the car. They're away from the car, therefore they can't now destroy the evidence that's back in the car. So anyway, that's theory number 3, search incident to arrest. If you arrest a person who's in the car, at the time of arrest in the car, then it extends throughout the passenger compartment of the car. If it's a recent occupant, somebody who's just stepped away from the car, more limited under the Gantt theory. And finally, theory number 4, an inventory search. If I have reason to arrest somebody and they're in their car or with their car, there are sometimes police department policies that say if you're going to arrest somebody, let's say for driving with a suspended license, and you say, I'm going to take you down to the station, but your car is here on the highway. We need to take it in. And when we do that, some departments say we're going to inventory the contents of the car. We'll just take a look at what's in the trunk and we'll take it out and we'll write it all down to keep track of what's in there. And that way we will protect ourselves, the police department, from any later claims that we stole something or destroyed something. We'll just keep a list here to help us keep better track of this property of yours that we are impounding, that we are holding until you can get released and can come reclaim your property. So that's an inventory search, and under federal law that's okay as long as you have some kind of legitimate grounds for the impoundment. It's you're not just picking somebody out and saying, hey, we're going to impound your vehicle. You have to have a proper basis for an impoundment, like, hey, you were driving without a license. You were driving with a suspended license. And if you can show that the purpose of the impoundment is not law enforcement, I'm not looking for evidence, I'm just looking to preserve your property. Maybe I'll stumble across evidence, but that wasn't my primary purpose. And then third, and this is probably most important, there's got to be some kind of standardized policy that the officer is following. They can't just make it up as they go along, but they have to be following a standardized policy, not necessarily written, but it has to be articulated and uniformly followed, or at least reasonably uniformly followed for it to count. But if you've got that kind of situation, the officer properly impounds, is not principally looking for evidence, they're just looking to preserve property, and then they're following a standardized procedure for impounding and creating an inventory of the property, then the police can look through the car to collect the stuff in the car and to write it all down in an inventory. And if you happen to find evidence of a crime, then that was an appropriate search. So those are our 4 theories. And let's just step back from this a minute. This is a big deal because Cars, this is the place where the police interact most often with citizens. We have these surveys nationally of citizens, when did you last encounter a police officer? What was the setting? How did it go? We ask this question of a big group of people every year. There's an annual survey. And we know that over half of the police-citizen contacts in this country every year happen with the person in the car. This is a high-volume encounter. This happens all the time. It's also a fairly recent phenomenon. We didn't have this going on in the 1880s or the 1900s, or not so much in the 1920s. It's become over time more and more the common encounter. So this is high volume law, fairly recently developed law, and law that's not really anchored by history because we don't have comparable factual settings for the older case law. So in this setting, the law has turned out to be very prolific, lots of analogies to older cases like Terry or Chamel, the search incident to arrest case. And in this setting, the law has given the government lots of different theories, and the outcomes are overwhelmingly pro-government in this car search setting. So if you're predicting what's likely to happen, if there's a car involved, best rule of thumb, best bet, government's probably going to win this one. We'll talk later.